I'll sit on the right side.
Petitioner. What is this? Oh, petition. Yeah, thank you. Do you have a pencil? Rubber and pencil. Yes.
Sir, we need paper.
You can read the, we know the. If you still want to read, you're welcome to read.
Sir, we can directly just give it.
Yeah, thank you. Yes. Can you proceed?
Good afternoon, esteemed judges and participants. I am Khushi Swami and my mate Shivangi on behalf of Maharaja Agrisena Institute of Management Studies. We extend a warm welcome to each one of you. A very congratulations TC21 and TC25 for making it to the finals.
As we embark on the final round of MAIMS, 4th National Moot Competition 2023, we are honoured to be in the company of judges of exceptional distinction. We genuinely appreciate your expertise, discerning judgment, and unwavering commitment to the legal field. Your presence epitomizes the excellence we aim for in this competition.
As we venture into this culmination of the final round of this competition, we anticipate that your insights and impartiality will elevate the participants' journey, adding luster to this evening.
We eagerly anticipate the unfolding of legal brilliance, expressing our gratitude for the time and effort you are dedicating for the same. Your role as judges is pivotal in shaping the course for inspiring legal minds. To honor the same, we would like to request Ms. Madhura ma'am to honor Professor Dr. B.T. Kalsar with sapling and memento as a token of appreciation.
Honorable former Justice N.K. Behel sir with the sapling and a memento. Last but not the least, Madhura ma'am will present a sapling and a memento to Advocate Satya Mitra as a token of gratitude.
is stepping into a day of legal expertise, lively arguments, and meaningful interactions as we officially begin the first round of 4th NSCC.
I would like the both masters to take over further. May the best team win. All the best and happy mooting.
Good afternoon to all. Before starting with the arguments, I would like to brief the bench about the functioning of this courtroom. I, Isha Shakya, will be serving you as Court Master 1 and will be assisting you with maintaining the decorum of the courtroom plus time moderation. And Apira will be serving you as Court Master 2 and will be assisting you with maintaining the decorum of the courtroom plus sharing of the relevant documents and time moderation. Further, as already stated, there will be 2 court masters present in the courtroom at all the times to assist the honorable bench. The court masters will act as facilitators between the bench and the counsel. The court masters will time the arguments and intimate the bench accordingly. The lordships are requested to please seek our assistance whenever it is required.
As stated in Rule 4, Subclause 3rd of the MAIMS 4th National Moot Court Competition 2023's rulebook, each side shall get a maximum time of 45 minutes to present their arguments, of which no speaker shall be permitted to address the court for more than 25 minutes. The time limit is inclusive for the time for rebuttal or sub-rebuttal respectively. The maximum time for rebuttal is 4 minutes and the maximum time for sub-rebuttal is 2 minutes. Each speaker is required to speak for a minimum of 20 minutes exclusive of time taken for rebuttals and sub-rebuttals. The order of presentation is Petitioner Speaker 1, Petitioner Speaker 2, Respondent Speaker 1, Respondent Speaker 2, Rebuttal, Petitioner, any one of the 2 speakers, Sub-rebuttal, Respondent, any one of the 2 speakers, where sub-rebuttals will be permitted only at the discretion of the judges. The judges may exercise discretion for extending the time for the oral rounds beyond the time specified in the rulebook. The rulebook provides that a time extension up to 2 minutes is permissible for each round. The team code for the petitioner is TC21 and the team code for the respondent is TC25. The total time is 90 minutes with petitioner speaker 1 presenting their side for 22 minutes and speaker 2 for 22 minutes, whereas the respondent speaker 1 presenting their arguments for 23 minutes and speaker 2 for 20 minutes. I now would like to seek the permission of the bench to start with the proceedings. Thank you, Lordships, much obliged. I now request the petitioner to start with the proceedings.
Greetings of the day. The council seeks permission to approach the dais. The council seeks permission to address the bench collectively as your lordships. Your lordship, the council shall be dealing with the first and the second issue, and the co-council shall be dealing with the third and the fourth issue. Your lordship, the council shall brief you with the facts in the very first few minutes and then move towards the outcome. So basically, in this fact, in the case that we are presenting and talking about today, here there are 3 subjective matters. First of all, my client, Mrs. Appu, is a renowned MP of state of Kent. In 2019's general election, she lost the election from a Bastion seat in state of Garhi. However, in 2021, she won back. Considering her rejuvenated popularity, she did a comedy roast show. Thereby, in 2022, in that same comedy roast show, she made a statement that was used by the respondents to file a case of defamation under section 500 of TPC. And for this very matter, she was convicted by the Chief Judicial Magistrate on 8th of February 2023. Now, due to her conviction, she was disbarred under the TRPR. On June 2023, the Secretariat recommended by-election even when the next general election were in less than a year. In the very same show that I have already talked about of the comedy roast show, Mrs. Naya, who was another comedian, mocked the Zoya religion and did obscene act against that religion, in which my client was also present. Due to this, FIR number 54/2022 was filed against her and the two others. Anticipatory bail in this regard was rejected by the High Court and the Session Court. Now we have talked about the two major.
What is the maximum sentence for this offence?
2 years as per the section 500 of the Act.
Is anticipatory bail maintainable in such cases? Is it a variable or non-variable offence?
My Lordship, for the very first thing I would like to clarify that the conviction under section 500 for the definition.
We're not dealing with the conviction, we're dealing with anticipatory bail.
Yes, my Lordship. It is a different matter. And secondly, Zoya religion, she was, the FIR has been
I am
filed.
dealing with a question. Anticipatory bail is maintainable only in offences which are non-variable offences. If it is a variable offence, I think it's a wrong advice.
Yes, my Lordship. That is what I am saying. In FIR number 54/2022.
And I am not sure whether a person, even after his conviction, can still go for anticipatory bail.
Section 153A, 295, 5051B and 5052 of IPC. Under these sections, the FIR number 54/2022 has been filed. Amongst these, the case of 295, for example, the case of a 295 is a non-variable. And that is why we have brought up the concept of the anticipatory bail here. Now moving towards the third major issue that has happened on 11th August 2023, another video of hers surfaced whereby she was found to be stating and inciting violence with respect to international delegates. The video led to the destruction of life and property and major riots. My client states that it is an AI created deepfake video and demanded removal of the video from the press bureau, but which they declined. For my client's anticipatory bail for this matter, in which is FIR number 19/2023, was declined by the Session Court and the High Court. Supreme Court of 10, seeing the interest of justice and the question of substantial law, question of public importance, transferred all the matters before itself. Now the council shall move towards the very first issue, whether Mrs. Aku is guilty of defamation under TPC, whether the subsequent conduct of the election under Power 151A of the TR Act violates the law. The council shall be dividing this issue in two major sub-issues. The first major sub-issue shall be telling you that Mrs. Aku is not guilty of defamation in the TPC.
Just let me be clear about one thing.
Yes, Your
What
Lordship.
are the offences under FIR 54/2022?
Yes.
And what is the punishment prescribed for those offences?
Yes, Your Lordship. Like for 295, for 54/2022, as mentioned
No,
in...
I'm not coming to, yes, 54/2022.
Yes, Your Lordship.
Yes.
As mentioned in the para 6 of the Moot prop, it has been stated, it's section 295A, which is deliberate and malicious acts intended to outrage religious...
Correct.
Okay.
Then what about FIR 19/2023?
19/2023 is for inciting violence against the video that incited violence
What is
against
the
the...
maximum punishment for that?
My Lordship, for this, there is also a matter of UAPA. So, subjective to the facts and the decision of the Supreme Court, it may also get towards still the life imprisonment.
Right.
302 is also there.
Yes, Your Lordship. Yes, so, referring, I would request Your Lordship to refer to the argument number 1 of, argument number 1.1 of the written submission.
All
The
right.
choke was not...
Which one? This is your submission?
Red, sorry, blue color.
Blue color.
Yes.
Yes. Let us go to 1.1.
Yes.
Yes. 1.1.
1. Argument number 1.1.
Yes.
Yes. So, Your Lordship, the joke was not directed to hurt anyone's sentiment. It was a comedy roast show. whereby the petitioner was interacting with one of its.
What are the words used by?
Yes, that is given in the para number 5 of the Moot proposition.
Yes.
Oh, you belong to Ati surname. Do you also evade taxes and police? This was the exact statement that has been used by my client.
Read it again.
Oh, you belong to surname Ati.
Which
Para number 5, Your
Yes.
Lordship.
Yes. Oh, you belong to the
To the surname Ati.
ATI.
Do you also evade taxes and police? So for this statement was made in a comedy roadshow, whereby I have always witnessed that there in a comedy roadshow there is usually an interaction between the public
What would have
and
happened if it had been still in an election rally?
obviously that would have had different consequences because of different circumstances, Your Lordship. Here the circumstances was that of a comedy show. Whatever was being said there was intended to be a joke. If somebody says that we have seen a lion flying there, it was obviously intended to be a joke and everybody to laugh and not as a mere fact. So, however, it was taken by the respondent, Mr. Baskinati, who was not even present in the show. It was merely referred to the one of the audience member, who was the person who was to whom it was referred. Now, the person Baskinati is not even an identifiable or a definite person to whom this was targeted. The audience member to whom actually the statement was referred to in a conversation, he never objected to such statement and never claimed it to be
It
hurtful.
says Mr. Baskin ATI.
Yes, Your
So
Lordship.
therefore it's like Modi.
But Your Lordship, when I am having a conversation with you, I am talking about you. I do not intend to connect it to any other person belonging to your same surname. There are
The
instances when
allegation is that you are referring to a community or section of the society. And therefore when you say, oh, are you also a tax evader? Does that mean that this particular community is a tax evader?
definitely not, my lordship. There has been many statements in this community whereby people are referred to their communities. Like for example, without hurting the sentiments of any of the community, if you belong to a Brahmin family, you're usually considered to be very smart and intelligent. So if somebody comes up and tells me that, oh, you belong to Brahmin community, you must be smart and intelligent. It is not supposed to be.
That is appreciating the thing, not
Okay.
denouncing the.
Okay, my
group of
lordship, but even if the case of an opposite way,
people. Suppose you say, oh, you are a Brahmin who practices untouchability. So then that becomes a different story altogether.
but my lordship, if in that situation I, the person to whom it was referred to, takes it on the heart, only in that case I would have said that, but the person who was present with the audience member, he never objected to this statement. He never claimed it to be a hurtful sentiment. He rather laughed it off. So this shows that member of Ati community is not actually the being who had heard. But basically, Mr. Baskinati, who had had previous animosity with my client, as stated in the clarification number 7 of Moot Prop, clarification number 7,
Where
that
is
they
the
have had
clarification?
number 7.
Alright, go ahead.
So for that, that means they have had previous animosity. So if just because my client is a very influential personality who is coming up and using the stage and using a very innocent statement that is taken up by the opposite party and just being using it to target him for the matter of elections and everything. The comedy show is a work of art and comedians have their own artistic freedom of speech and expression as stated in the Ashutosh Dubey versus Netflix case. Now,
Which is the case you are referring to in this?
Ashutosh Dubey
Have you
versus
referred to it?
yes, Lordship,
Which
para,
page?
number, para 5 of the movement.
Which page?
Yes, sir.
Page 13. Right.
So,
Alright.
in this case, Vedas was a person who was a
No
comedian.
problem, you go ahead.
Okay, Your Lordship. So now moving towards the limb 2 of the arguments. I request your Lordship
So
to
how do you
refer
sum up your first argument so far as question number 1 is concerned?
It is still to continue that I would like to point out few more things. First of all, paragraph 14 of the case I would like to submit.
Paragraph 14 of the case.
I would like to submit this
Which case?
case. Harsh Mendira case versus Maharaja Singh. In this very case, it has been
Which
clearly.
court? Is it Supreme Court?
It is of Delhi High Court. In this very case,
Is it single judge?
it is division bench.
No, it is before
is-
Justice Devi.
Oh, sorry.
Yes.
The-
Which paragraph?
Paragraph number 40.
14.
Yes.
1-4.
Yes.
Yes.
So-
Moreover, the settled position of law appears to be that an action for the defamation is defamable only by the person who is defamed
And not
and
by.
not by his friends, relatives and family members
Exactly.
upon
So
the purposes of interior relief.
So exactly, I would like to point out that here the person to whom the defamation was, even if we consider it to be a defamatory statement, it should have been from the audience. But here that audience member is not coming up and presenting its point. Here rather any other person is just coming up and saying that, oh, this statement have been said and I am hurt, my feelings are hurt.
So anybody can set the law into motion? Anybody can set the law into motion,
No,
even if he is not affected?
exactly, that is my point. That is why we should only talk about people who are actually being directed to in this statement. Here,
You see, this is on the basis of a complaint.
yes.
And this is not on the basis of an FIR.
Yes, you're right.
FIR can be filed by anybody. What my lord is asking you is locus of a person to file the complaint.
Here,
So
there is
therefore,
no
can
locus
anybody
stamp.
come and file the complaint?
No, my lordship, the person who is being hurt and whose sentiments are being hurt.
But
is
suppose
that
he
person.
says, I belong to this community and the whole community is hurt, therefore as a member of the community I am filing this complaint. How
But,
do you deal with that argument?
but your lordship, there is not actually any other member coming up. Why is only
How
that
many members
person?
is sufficient?
Yes, your lordship, definitely just one of the person and representation is sufficient. But there is no proof
It's
that
a matter of trial when other people will also come and give evidence that they were also hurt. But on the question of complaint, I think one person's complaint is sufficient.
But in the matter of the fact sheet has been silent whether any other person has been hurt. So, assuming the situation, and most importantly, the situation.
Just for your
Yes, your lordship. And classes of person in cases of defamation cannot be used by any reasoning here, because the community here cannot be taken as a class of person, because it is only when each and every member of the society is being referred to, or that class is being referred to. Here it was merely referred
So
to.
are you saying that for this community as a whole, suppose the community belongs 5 lakh persons. So is it your argument that if 5 lakh persons all are coming, only then community is hurt? 1 or 2 persons are coming, then community is not hurt. Is it your argument?
No, my lordship. In the very same case of Ashutosh Dubey versus Netflix, here Veerdas made a comment on lawyers as a whole. So here the apex court held that lawyer as a
not Apex, Delhi High.
Delhi High Court held that lawyer as a whole cannot be defamed, because a specific person cannot be pointed out here that okay, that particular lawyer is being defamed here. So considering the same jurisprudence that was followed here, I come to this argument. Now, third part of the limb highlights that right to reputation of an individual is not being harmed here. When do we say that reputation is being harmed? Only when people lose faith over a person who is actually an
A
enemy.
statement which has a potentiality
Yes, your lordship.
of lowering the prestige of the person in the eyes of the people.
Exactly.
Even if it may not actually have happened, but if it has the potentiality of having that effect, it amounts to defamation.
Exactly, your lordship. Exactly to the point that when it has a potential. Here the statement is in a form of a comedy. It would be a very foolish of any reasonable person to refer it to an actual
I
assertive
don't
statement.
think we use the word foolish
Sorry, your
in the
lordship.
court proceedings, right?
Sorry, your lordship. I'll keep that in mind. Now, freedom of speech and
Don't
expression.
say imprudent.
Okay, lordship.
Impolite.
I will learn that. freedom of speech and expression under Article 19(1)(a) of the Constitution is guaranteed and also guaranteed by various
But
other.
this is not an absolute right.
Yes, it is not an absolute
And
right.
defamation is one of the restrictions.
Defamation is a restriction, but however, Article 19(1)(a) also states, as stated in the similar case of Ashutosh Dubey, that artists have their artistic freedom of speech and expression. Here, my client, who is on a comedy show, is being referred to as a comedian, should have his own artistic freedom of speech and expression. Now, moving to the second part of this major issue, whether subsequent conduct of the elections under power of Section 151(a) of TRT Act violates the law. Section 151(a) of the Representation of People's Act mandate ECI to fill the vacancies of the Parliament/State Legislature through the by-elections within 6 months from the date of the occurrence of the vacancy, provided that the remainder of the term of a member in relation to a vacancy is 1 year or more. This law is clearly stating that whenever there is less than 1 year left in the next general election, in that case, by-election should not be conducted. So it is a law which should be followed in which is written in black and clear words, which should be followed here. The powers conferred by the Constitution in Article 324, which gives Election Commission the power to superintend, direct and control the elections, are neither absolute nor unilateral.
Yes, Mr. Counsel, at page 5 of your memorial, you have referred to Constitution of India, Section 324, Section 19A.
It's a typographical error, Your Lordship.
Okay, then last item at page number 5 is 11, Code of Criminal Procedure, Section 437. Whereas you are claiming anticipatory bail,
In Section 438, again
you
I
have
would
not referred to that.
that is again I would say a typographical mistake that we would have made in a just of moment.
That should not happen.
Apologies for that, Your
When you
Lordship.
are dealing, you are in the apex court.
Yes, Your
As you
Lordship.
put it as apex court.
Yes, Your
You
Lordship.
have to be, that's why Supreme Court had to recently tell advocate and records
Yes, Your Lordship.
some advice they have to give.
The council
They should
seeks.
read the brief before they file it in the.
Sure, sure.
And
Your
case
Lord-
number 32 also you have written Union of India versus Tulsi Ram Patel. Citation is only 3 SCC 398. No year is mentioned.
1988.
Year is not mentioned, no? Anyway, go ahead.
These things should not happen.
Yes, Your Lordship. Your Lordship, the council seeks an extension of 2 minutes.
You still have 3 minutes.
Yes,
You
Your
finish
Lordship.
your 3 minutes, then we'll consider.
Okay, Your Lordship. Now, moving to the second issue that deals with, again, I'll be dividing it again in 2 major sub-issues. Firstly, the petitioner was charged in FIR number 54/2022, whereby she was denied anticipatory bail for she was found laughing and enjoying the skit, whereby the Zoya community was insulted by another comedian. The petitioner was merely present there, like any other audience member. So, should the presence of my client make him liable for such grave charges? Secondly, the petitioner should not be liable for the actions of the co-accused. Now, moving towards the second major sub-issue, whereby my client was charged under FIR number 19/2023 over a video that surfaced out of the blue, in which she was found inciting violence against international delegates as claimed by everyone. However, the fact sheet is silent on what actually the contents of the videos are. And I would also like to point out, when we went to press bureau before my client anticipated any kind of an arrest, the press bureau completely declined to remove such videos. That would again result to harm the reputation of my client. My client claims it is a deepfake video, and there has been no physical evidence that was ever retrieved from the petitioner or otherwise which could connect the petitioner to any violence that was ensued there. There was no disclosure statement which could be attributed.
Counsel, in what cases do we bring the vicarious liability? You said my client was only sitting there as one of the members of the audience, and she could not be made an accused merely because she was laughing at something that was being exhibited there. In what situations, if we have to rope her in as a group liability, what is the section we should charge?
The counsel.
Just one, you can clarify this.
Yes, please retrieve the question. Sorry.
I say criminal law basic liability is individual liability. But there are situations where we bring in group liability. What are those situations where we bring in group liability? What is it that should be proved? Or that should be one of the part of the charges to bring in group liability? I'm only referring to what you say.
Yes, Your Lordship. Here in the present scenario, she was there as an audience. Can all the audience present there be held vicarious?
Are you saying that there is no charge? There is no acquisition?
Yeah, and you have mentioned section 34, 120B,
Yes.
149 also. Are they dealing with the vicarious liability?
Yes, Your Lordship. I would again like to just clear one thing, that FIR that I am talking about related to Zoya religion deals with 153A, 295, 5051B, 5052.
Please explain
Yes.
if this case was registered at police station or was a complaint filed
It was
in
an FIR.
court of judicial magistrate?
It was an FIR.
These are FIRs.
FIRs,
Yes.
not complaint
No,
case.
no Lordship. And secondly, Your Lordship, there needs to be common object. Common object between the
Common intention or common object?
common
Why do we
object.
talk about common object?
Object when same goal is supposed to be.
141. It is
Okay, Your Lordship.
unlawful assembly.
Yes.
The common object.
Yes, Your Lordship. That can
149.
be one of them. Then.
Anyway, go ahead.
Yes, Your Lordship. So here there was no common object to defame the
We can't say common object. Either
Common
situation to say
intention.
common intention. 34.
Yes, Your Lordship.
Is 34 a substantive offense?
Please repeat
Is
that.
34 a rule of evidence or a substantive offense?
Just a moment of indulgence, please.
You will not get it from IBC.
Sorry, Your Lordship. Your Lordship, moving ahead with the arguments.
34 is a rule of evidence.
Rule of evidence.
It's not an offense. Whereas 149, 141 is an offense.
Yes, yes, Your
Punishable
Lordship.
under 143.
Yes, Your Lordship. So,
Counsel, your
Your
time is running out. Please tell
Just
us under which
concluding my-
article you are approaching the Supreme Court.
Your Lordship, under 139A, I would like to again clarify that
139A.
Supreme Court took the suo motu cognizance to extend its jurisdiction and bring up all the cases before itself.
No, but we have
See,
come to the Supreme Court under which provision?
Uh,
Have you come in a writ or have you come in appeal?
Your Lordship, when we were before the High Court, we were under Article 226, that was in the writ form. However, when Supreme Court took the suo motu cognizance,
They took so much cognizance to transfer the matter.
yes,
So
yes, Your Lordship.
it said it has the power to transfer the
Yes,
case.
yes, Your Lordship.
But you approached the court under which provision?
Then,
Let us look at the
Your opposite side writes under Article 136 of Constitution.
that is special leave to appeal.
Is it your special leave to appeal?
Your Lordship, this shall come before to you in under Article 32.
That
That
is
is,
writ petition when a fundamental right, you come into the, for
Your
enforcing
Lordship.
fundamental right. You come against the order of the High Court.
here
Have you come
the,
against the order of the High Court? Let us look at, can you see the page? Mrs. Aku moved to the Supreme Court citing that the current provision TPR violated the fundamental rights and constitution.
that
So
is
therefore we
for
come under
TRT.
32.
That
You are
is for
come under
TRT.
32.
Yes, yes, Your Lordship.
So is it your SLP or 32?
32.
32?
Yes,
Sure.
Your Lordship.
So which fundamental right is
Shared
violated?
already. Sorry, I misinterpreted the question. First of all, Your Lordship, right to reputation was being infringed here. For the defamation conviction, the artistic liberty of
You
freedom
go
of
to para
speech.
7 and then para 8.
Para 7. Yes, Your Lordship.
The parties they moved to the High Court of Delhi and anticipatory was denied them as well. Subsequently, the petition was filed in the Supreme Court for grant of bail as there existed no case and evidence for them to be arrested. So, grant of bail cannot be under 32.
Yes.
Yes, Your Lordship.
Grant of bail can only be under 136
136.
against the order of the High Court.
Yes, Your
Right?
Lordship.
So 138. Then come to para 8. Mrs. Aku moved the Supreme Court, citing that the current provisions under the TP Act are violative of the fundamental rights and the Constitution and challenging the virus of the provision. 32.
Yes, Your Lordship.
The two petitions.
Exactly, Your Lordship. That is what I have been wanted to point out, that there has been clubbing of the matters. Here, few.
Clubbing is of the matters pending before all other courts.
Yes.
This matter, one pertains to virus,
Yes, Your Lordship.
constitutional validity of the provision. Second leads to the denial of bail.
Yes, Your Lordship.
I do not know whether you say about bail or you talk about anticipatory bail, because the facts are not very clear.
Your Lordship, it is about, again, anticipatory bail as mentioned in the
But we say bail,
fact sheet.
bail is, when we say bail, it is post-arrest.
Yes, Your Lordship.
Anticipatory is pre-arrest.
That is why I am pointing out that we are here pre-arrest. We are not here after the arrest.
Thank you very much for your, you sum up in 1 minute. whatever
Yes,
you
sure,
have.
Lordship. So, secondly, my client should be presumed innocent until
That is
proven
the
guilty.
presumption
It is presumption in your favor.
But I don't know
Petitioner-
what we do with UAPA.
Petitioner is a responsible citizen of state of Kent. She belongs to a family of politicians
Where
and who
read
have
that?
been.
Read that. Now you sum up in 1 minute all your arguments.
So, Your Lordship, for this very reason, as I have already stated, the essentials of anticipatory bail can be fulfilled here. For example, like the essentials in this, that the individual should make himself accessible, must provide local police station with the current residence address, should not offer any inducement to tamper the evidences, should not leave the
She's an
territory.
influential person, she can tamper with the evidence.
She is
She
member
can
of parliament.
influence, she's a member of parliament.
But Your Lordship, she is also influential. Why are we seeing her with the lenses that she would obviously tamper the evidences just because she is coming from an influential
Mr.
personality?
Chidambaram was denied anticipatory bail, you know that?
Yes, Your Lordship, but however,
Why?
for being an influential personality. But Your Lordship, what I would like to point out here, she comes from she is a beacon of hope for the people, as pointed out in the fact sheet. So for this reason, this shows how much she has been connected to this
Next,
party.
on the question of virus of the provisions. They come also for
Please retaliate.
TRP Act.
Yes, Your Lordship. So for the TRP Act,
Is your other colleague council dealing with that?
she is dealing with UAPA and the IT Act guidelines for the individuals.
Okay.
Thank you, Your
Thank
Lordship.
you very much.
My co-counsel shall be continuing with the further arguments.
I appreciate your assistance.
The council seeks permission to approach the dais.
Good to see all the girls doing well.
The council seeks permission to proceed with the issues. The council is going to deal with issue 3.
Please tell us, this was your SLP, part of it SLP,
Yes.
whether you had obtained certificate of fitness from the High Court
Uh,
before going into SLP or not.
Your Lordship, the fact sheet is silent on
You tell us what your mind says, whether certificate of fitness is required from the High Court or not. And if refused by the High Court, then
Your Lordship, the council seeks a moment.
Now your other colleague can, she can help us if you know.
Yeah, if you know, you can answer.
And is it necessary for 136 invoking the jurisdiction of the Supreme Court to get certificate of fitness? Or it is somewhere in other provisions of the law that if you have to appeal against the order of the High Court, you have to get the certificate of fitness that involves substantial question of law.
Yes, Your Lordship, we are supposed
Stand
to.
up.
Sorry, Your Lordship. Yes, Your Lordship, we are supposed to get the fitness of certificate.
Under 136,
Yes, Your Lordship.
are you sure?
I'm not sure about the.
Okay. So whether your SLP was admitted initially or not? Because once the SLP is admitted, it becomes a
Civil,
regular.
it becomes a civil appeal or criminal appeal.
Becomes a regular. So whether your SLP was admitted initially or not?
Your
Or
Lordship,
are you arguing for admission of SLP?
Your Lordship, we are arguing for admission of SLP.
Okay.
Please.
The council is going to deal with issue.
SLP is the discretionary jurisdiction of the High Court, of course, against the order of the court or tribunal. It has to be judicial or quasi-judicial, right? Not administrative body in 136.
The council is going to deal with issue 3, which is that whether under the fake news guidelines a person can be arrested for a deepfake video and whether the fact-checking unit was justified in denial of removal of fake news, and issue 4, which is that whether the 2019 amendment of the UAPA places a fetter on the right to dissent and violates freedom of speech and expression, and whether the unilateral power of the executive under section 35 to categorize an individual as a scheduled for offender is against the settled principles of law.
Which amendment you are talking? Which amendment? 29th.
Say, 2019 amendment of the UAPA.
29th amendment.
2019 amendment.
19 amendment.
2019
Okay.
amendment.
2019. Okay.
The council seeks permission to proceed with issue 3. The council would deal with the second leg of issue 3 first, that the fact-checking unit was not justified in removal of fake news. The council humbly submits that the right to reputation of the petitioner is being violated by the denial of removal of fake news. Article 21 of the Constitution states that no person shall be deprived of his life or personal liberty except by procedure established by law. In the case of Maneka Gandhi versus Union of India, it was held that the term personal liberty possesses the broadest interpretation, and consequently, the scope of personal liberty witnessed expansion to include a wide range of right over the years. And one such right that evolved was the right to reputation. In the case of Kishore Samit versus State of UP, it was
What is so much, when we talk about Maneka Gandhi, what is it that makes it landmark decision?
Your Lordship, Maneka Gandhi has been called the watchdog of democracy. As before this, Article 29 was interpreted very
21.
21, my apology. The Article 21 was interpreted very narrowly. After Article 21, after the Maneka Gandhi judgment, different rights such as right to sleep, right to food, right to livelihood has been included under Article 21.
But what is outstanding about this? Why do we every time, in every branch of law, refer to Maneka Gandhi? Not as a person, but as a judicial decision.
Have you
Constitution
heard
being
of principle of audi alter partem? Was it involved in this case?
Yes, Your Lordship. That each side must be heard.
Okay.
Reasonable, very broad due process. The procedure must be fair, just and reasonable.
Your Lordship, before, in the case of A.K. Gopalan, till the case of A.K. Gopalan, in Article 21, because of procedure established by law was mentioned, reasonability was not important. But after Article 21, procedure established by
Not
law...
after 21.
Sorry, after
Maneka
Maneka
Gandhi.
Gandhi, I'm extremely sorry. After Maneka Gandhi, procedure established by law, there had to be
Just
reasonability.
reasonable and fair.
No, that's fine. What support you are drawing from Maneka Gandhi's case for your petition?
Yes.
Your Lordship, the case was cited to explain
Dignity,
the
we were talking
evolution
about
of
the
right to
dignity.
reputation.
The term dignity was included in Article 20.
In the case of Kishore Samit versus State of UP, it was held that reputation can be defined to be good name, credit, honor or character, which is derived from favorable public opinion or esteem, and character by report. And reputation is an element of personal security and is protected by the Constitution, equally with the right to enjoyment, life, liberty.
So therefore, what is your argument?
Your Lordship, the argument is that when the fact-checking unit denied to remove the video, which is deep fake, according to the contention of our client, the reputation of our client is being severely damaged because our client has done nothing wrong and the reputation.
So then, if suppose your client is saying that remove this video, whose liability comes in?
The fact-checking unit's liability. And the fact-checking unit was supposed to investigate if it was a deepfake video or not. But the fact-checking unit simply absolved from the liability and did not carry out any investigation on its part.
So therefore, what should happen? Who is liable? Your client is not liable. Who else
The
should be
government
liable?
is liable, and the government, when the video surfaced, the government should have removed that video, which the government did not do. And then the riots happened, and the government could not control that.
Which case you have cited in support of your argument right now? Kaushal Kishore.
In the case of Kishore Samit versus State of U.
It's not contained in your
Which is
list of
contained,
documents?
is it contained in your document?
No.
Kishore Samit, yes,
No.
sir.
Is it?
Yes.
Which page?
Kishore Samit
Page
is
number 656 is the list of cases which you have cited.
Kishore Samit is
Serial number? Tell us the serial number.
in the list of jurisdiction or not?
And the list of cases in the beginning.
One of the things that you should always do, alphabetic. When you read, will
Yeah.
give the list of the cases.
Should be alphabetic.
It is very easy to find when you give it alphabetic.
Apologies.
Okay,
Well,
whatever support you are drawing from this case,
It's not there.
it's not there, okay,
Your
we
Lordship,
understand. But was it the ratio decidendi of that case which you are taking support in your case?
Your Lordship, apologies that the case is not mentioned in the index
No
of
problem.
authorities. However,
Doesn't
if
matter.
you
Doesn't
if
matter.
Which part? Where is
you
it?
refer to footnote, if you refer to page number 21,
Thank you.
in the citation number 33, it has been mentioned. The council really apologizes for the
Footnote number
Yes.
33 you mean to say, huh?
yes. Your Lordship.
33 is,
Kishore Samit versus State.
yes.
33. Fine,
Your
I am
Lordship.
asking what was the ratio decidendi of this case?
Your Lordship, the ratio descendi was the facts of the case were related to a member of a legislative assembly who said some facts or who said defamatory facts about a person, another MP, that he raped a girl. Then the court said that such facts cannot be said without any basis, and the ratio decidendi was, as I have said, that reputation is
Is an element of
is an element
personal
of the person.
security and is protected by the Constitution.
Yeah,
And right to enjoy reputation, good reputation is
a personal
part
right.
of the right to life.
And reputation is not only a salt of life, but the purest treasure. So reputation of the of Mrs. Aku is, as mentioned in the Moot prop.
Mr. Counsel, you have cited the case of Shaira Banu versus Union of India also at serial number 25. What is the relevance of Shaira Banu here?
Your Lordship.
At page number 7 of your memorial,
Your Lordship.
serial number 25 cases, Shaira Banu versus Union of India,
Your Lordship,
2017, 9.
Shaya Banu was cited to establish that Article 14 strikes it that to establish that 3.2 that the fact-checking unit is the power vested with the fact-checking unit is manifestly arbitrary. As the IT guidelines that are there,
No, but no such issue was involved in Shaira Banu's case. It is triple talaq case. It has nothing to do with your defamation.
Your Lordship,
Are you appreciating?
Your Lordship, the current fact number 3, issue number 3 that I am dealing with, that is not related with the defamation case. That is related with the deep fake video case, and it is related to the UAPA. In the UAPA, there was it is related with the fake news guidelines in 2020.
No, that's fine. I'm saying how Shaira Banu's facts are similar
Also,
to
the
your
Shaira
case.
Banu's case is validity of the triple. The Constitution bench judgment where 3 different judgments you can see.
So how that case is relevant to your case?
Court holding, one judge holding, validity of Article 14, other judge holding not a not a practice. Other things, the minority saying it's a part of the religion.
Your Lordship, in the case of Shaira Bano, by a 3-2 judgment, the judgment had said that Article 14 is violated. The personal Muslim law was violating Article 14. The reasoning that was given was that Article 14 was violating the rights of equality of the women because they were not given the right to divorce. So this case was established with the intention to legal authority to the
What my lord is asking, he says, where is this case, even if you take support of Article 14 and Shaira Banu dealt with, I think Justice Korean Joseph, not Justice Korean, Justice
G.A. Basu.
Justice Nariman dealt with Article 14. How is it important to your article?
Your Lordship, usually in cases containing constitution.
Be composed. They are not helping.
In cases which are related to constitution, in most of the times, the facts are not that relevant and the argument.
No, I'm not saying. I say, how are you in your argument on issue number 3?
Yes, sir.
How do you draw support?
Your Lordship, in the case of Shaira Bano, it was held that Article 14 strikes
it
an
is arbitrary practice.
It is arbitrary.
Correct.
In the fake news guidelines in 2023, that came out, Section B, as I have cited in para 37, in respect of any business of the central government is identified as fake or false or misleading by such fact unit of the central government as the ministry may, by notification published in the official gazette. This is the only mention of fake news in the whole guideline.
So therefore, it gives arbitrary powers to the government.
The government has an arbitrary power, and this is what happened.
And therefore,
in
when
this
it is
case.
unguided power, it should be struck down. Is that right?
Yes, sir.
So which kind of writ you want this court should issue in your favor finally?
Your Lordship,
Out of 5 writs, which writ should be issued in your favor?
Your Lordship, the writ of mandamus to command the fact check unit to investigate and then to remove the video from the social media platform.
Proceed.
Proceeding with 3.2, as I've already established that the fake news guideline should be struck down. Proceeding with the
In
issue.
mandamus, we cannot strike them down. We can only command to do a thing. Why do we? I think it's writ of certiorari.
Your Lordship,
Go ahead. Not get
It's
stopped.
a learning exercise, please go ahead.
We are here to help you. Okay. Distract.
the nexus test was enunciated in the Anwar Ali Sarkar case, in which there were 2 conditions that were there.
Intelligible
The
differential,
intelligible
reasonable
differentia
classification.
and the reasonable classification.
Nexus between the two.
Yes, Your Lordship. In the fake news guidelines, 2023 do not pass the first test, as I've already established that they are arbitrary. And second of all, there exists no rational relation to the objects sought to be achieved by the Act, as the rules may be going beyond the scope by adding a new principle of false information and a new category of intermediaries. The Act does not provide for regulation of false information, nor does it delegate the power. These things should be done in the IT Act 2000, and under guidelines, the government cannot establish such rules. Then, coming to the third issue, that a person cannot be arrested for a deepfake video under the fake news guidelines. Deepfake involves the analysis of number of data samples to mimic a person's mannerism, facial expression, voice, inflections by deep learning algorithm known as generative adversarial networks. There are no such provisions as of now in any
IT
IT Act to specifically deal with deepfake, and thus a person cannot be arrested. Proceeding with issue 4, which is UAPA, whether the amendment places a fetter on the right to dissent and thus violates the right to freedom of speech and expression, whether the unilateral power of the executive under section 35 to categorize an individual as scheduled for offender is against the settled principles of law. In Minerva Mills case, it was established that Article 14, 19, 21 constitute an integral part of Constitution's basic structure and they cannot be abolished. Fundamental rights are regarded as the core of the Constitution. They are interconnected, mutually reinforcing, and pivotal to the Constitution's essence. The amendment of 2019 basically said that in section 35, before the amendment, only an organization could be notified or notified as a terrorist. However, after the amendment, an individual can also be notified as a terrorist. So, the amendment violates Article 14 as the amendment is manifestly
Can't a single person become some class and be put in the schedule? Why not?
Your Lordship, the contention is that
See,
there are no safeguards against it. It is as the same thing that happened with the fact-checking unit, that the amendment is arbitrary and violates the principles of natural justice as there is no chance given for the other side to be heard. It is totally on the discretion of the government and there is no procedure as such which has been provided with. Section 35, Clause 2 of the POAP Act provides the government unbridled power to declare any individual or organization as a terrorist based on just the belief of the government and detain that individual without any judicial proceedings. Absolute and unfettered power is violative of Article 14 of the Constitution. In Union of India versus Tulsiram Patel, it was held that principles of natural justice have been integrated into Article 14 by dynamic interpretations of the court, and thus amendment is violating Audi Altum Partum.
What was Tulsiram Patel's case about?
Your Lordship, it was a club.
It was relating to Proviso 2 to Article 311.
Apologies, Your Lordship.
It was related to one, constitutional validity of Administrative Tribunal Act. Second, the opportunity where a person would not be given opportunity to what was available to him under Article 311 under the second provision 311. And till that time, courts would backdoor bring in Adi Altram Paraton, but when the court said in Tulsiram Patel, when the provision, second provision is specifically clear, you cannot make backdoor entry for the Adi Altram Paraton. So therefore, Tulsiram Patel is dilution of the rights of the people.
Your Lordship, in Tulsiram Patel, there were facts relating to that if Tulsiram Patel was a chief auditor whose increment was held for a year, and then as different petitions were clubbed together of the government officials being unjustly dismissed.
Because they thought it was contrary to the national security. They were some officers from the RAW.
Your Lordship,
Am I right on this case? Just read this case.
Your Lordship,
Is it on Article 311 of this?
Indeed.
Yes. Second provision.
Okay, see.
All right.
Section 35 of the UAPA Act indicates no provision for an oral hearing. The government has unbridled power to declare anyone as a terrorist. Proceeding with issue 4.2.
Can I have a copy of that, Tulsiram Patel? You have it? All right.
4.2.2, it has already been established by the
It's
Council
Justice Madhan's
that Article 19, 1 Clause A is violated as right to reputation of an individual is being infringed. Proceeding with issue 4.2.3, as already established in the fact-checking unit, that the right to reputation as an integral
No, you
component
don't have to read it. You just.
of fundamental component of life, and labeling or tagging of Mrs. Aku as a terrorist when it was a deepfake video injures her reputation. It is stated in the Moot that she is a very popular politician amongst you. She has been a beacon of
Rahul Gandhi is also popular politician.
I disagree with that.
Okay, Mr. Counsel, your time is running out. Please see your footnote number 48 at page 26. Page 26 of your memorial, footnote number 48. 48. What is that? Please read out.
48. Footnote number 48.
Yeah.
That is idiom.
What does it mean? ID?
IDEM is, as the Blue Book citation goes, when you are directly citing the authority above it, which is in this case Maqbool
It
Fida
is
Hussain.
image, short form of image.
Maqbool Fida
But
Hussain.
it
When
should
you
come
are-
on the same page. If you are citing
If you are
IBID,
citing, then
it should come on the same page. If the page is changed, then you will have to refer Supra Note 47. If the page is changed, Supra Note 47. If it is same beneath it, then you can use IBID. All right,
1 minute left. Please sum up your arguments now.
Your Lordship, the surface of the video has been the client is not at all liable in this manner because it is a deepfake video. She is the one who is the victim in this case of the deepfake video, and this video.
Why did she not file a case against him? She should have filed a complaint or an FIR.
Your Lordship, the fact sheet is silent on that matter, but she did a press release in which she stated that it is a deepfake video, and she also approached the, before filing a case to remove the video, she approached the press bureau, but the press bureau did not agree to that. And her various rights, fundamental rights were violated, Article 14, Article 19, Article 21. Your Lordship, the council seeks permission to proceed with it.
With?
The prayer.
You know your prayers.
Prayer, you know. Mr. Counsel, are you not referring to these sections in FIR number 19? 120B is there, criminal conspiracy. 34 is there, common intention. 149 is there, common object.
Which of these are you
All
relying
these
on?
sections can be clubbed together in one charge?
Your
You
Lordship,
are not hitting.
Your Lordship, issue 4 as mentioned in the Moot.
No, I am asking you in general. FIR has launched these three sections. Can they be applied simultaneously in one case? Criminal conspiracy we have, common intention we have, common object we have. Is it possible theoretically?
Yes, Your Lordship.
Is it possible? Either you can have common intention, or you can have common object, or you can have criminal conspiracy, but not all the three.
When you put 149, you will move back to 34. But from 34 you can't go to 149. 2, 5. 149 presupposes 5 people of the group
Yeah.
with a common object. 34 says 2 or more persons. In furtherance of the common intention of all. Where a member of a group, where 2 or more persons having common intention, and there has to be participation in action in furtherance of the common intention.
So sections can be applied, but in different set of circumstances, not in one case. Okay.
These are learnings,
Thank you.
Indeed.
vast experience of my Lord.
All right. Thank you. Thank you.
Thank you. Thank you.
The council seeks permission to proceed.
Yes.
Much obliged.
Why is it that girls from one side, boys from the other side? This is a system of exclusion.
It's a fair process. I will show you that.
Fair classification.
Huh? This is a system of exclusion.
Okay.
Good afternoon to the honourable bench. If it may please, the council seeks permission to address the bench collectively as your lordship. Much obliged, your lordship. The council is appearing before the honourable court on the matter of Mrs. Aku versus State of Ghadi on behalf of the respondents, seeking the jurisdiction under Article 136 of the Constitution of 10. If your lordship is well versed with the facts, the council would like to proceed with the issues, highlighting just a few portions of the facts that my most worthy opposing counsel failed to inform the honourable bench.
They will only refer to the facts which
Certainly, your lordship.
are helpful to them.
Certainly.
You have to refer to the facts which are not helpful to them.
Your Lordship, the council would, in an impartial manner, refer to the facts.
That's the duty to the court
Certainly.
as an officer of the court.
Certainly. Your Lordship, that the kind attention of the bench be drawn to paragraph number 4 of the facts.
Yes.
Your Lordship, line number 3 states, the series will include 4 comedians who will pair with different celebrities from various fields, and one of them selected was Mrs. Aku. Your Lordship, the whole contention of the most worthy opposing counsel was that Mrs. Aku acted as an artist, acted as a comedian, but Your Lordship, in the present case, she was a celebrity, she was an elected member of the parliament, and she was here as in a capacity of a celebrity, not as a comedian or an artist, Your Lordship. Your Lordship, further reference may be drawn.
But then you see, it is selected.
Certainly, Your Lordship.
Selected can be among the comedians only, or people who have the potentiality to be a comedian. See, look at the facts. You refer to the facts.
Yes, Your Lordship.
The series will include 4 comedians who will pair with different celebrities from various fields, and one of them selected was Mrs. Aku.
Certainly, Your Lordship.
So you say that she was not a comedian, she was a celebrity.
Yes, Your Lordship.
So therefore she cannot, as a comedian, take the rights of a comedian, enforce the rights of a comedian.
Certainly.
Is that the dark? So
Certainly.
she is enforcing the rights of writers, the right to freedom of speech.
Your Lordship, the council will be proceeding in the further contentions that right to freedom of speech is not absolute. It has to be curtailed when it is referring to or it is promoting enmity between a religion, Zoya community, and the defamatory statement that was casted by Mrs. Aku as well, Your Lordship. Your Lordship, further referring to the facts of the case, Your Lordship, paragraph number 9, if Your Lordship please may refer. Para 9 of the facts, line number 18.
Yes.
Your Lordship, it states Mrs. Aku made a press release before her arrest. Your Lordship, in the present case, the petitioners have moved for an anticipatory bail. Your Lordship, anticipatory bail is a pre-apprehension
That's
arrest.
why I put the question. I said, is it an application, is it a case of bail or is it a case of anticipation?
Certainly, Your Lordship. Your Lordship, the appeal as to
Once
regard
a person is arrested, the anticipatory bail application becomes, it's almost infectious.
Certainly, Your Lordship. That's the contention of the council, Your Lordship. Your Lordship, the council will be dealing with the first 2 issues. Proceeding with the first issue, whether Mrs. Aku is guilty of defamation under Tempt Penal Code. Your Lordship, it is humbly submitted that the reference may be drawn to section 499 of the Tempt Penal Code, which clearly states whoever by words, either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said to defame that person, Your Lordship. Your Lordship, it is humbly submitted that not only intention or knowledge, but reason to believe is an additional factor.
Why is reason to believe defined? There is a definition of reason to believe in IPC. You are aware about that definition?
Your Lordship, the council is not aware as to the exact provisions of
I
the...
think somewhere, do you have the IPC?
Yeah.
46 or 44? 46? Or there is a definite definition of reason to believe.
Certainly, Your Lordship.
Just read reason to believe. What is the difference between knowledge and reason to believe?
Your Lordship, the difference between knowledge and reason to believe. Your Lordship, the difference between knowledge and reason to believe is that, Your Lordship, knowledge is when the person has the requisite information and has the mental capacity to infer that a certain statement would be incurred in a certain way, Your Lordship. That in this case, the defamatory statement, Mrs. Aku had the knowledge as well as the reason to believe, Your Lordship. Mrs. Aku is an elected member of the parliament, Your Lordship. She has the knowledge, she has the...
I said this is 40? 26. Yes, 26. Just read 26.
Your Lordship, the barrack has been submitted, Your Lordship. So, can I please
Read it.
I read it.
I would like to, I'd like
A
to
person is said to have reason to believe a thing if he has sufficient cause to believe that thing, but not otherwise.
Certainly, Your Lordship. Your Lordship, in the present case, there is sufficient cause to believe, on behalf of Mrs. Apu, that a said statement to a particular
Why I
community.
ask you, knowledge and reason to believe. You go to the definition of voluntarily, 39. Have a look at 39. A person is said to cause and effect Newton's laws of motion voluntarily when he causes it by means whereby he intended to cause it, or by means which at the time of employing those means he knew or had reason to believe. Are you following me? Had reason to believe to be likely to cause it. Not may cause it, not possibly cause it, likely to cause it. So therefore, when you say reason to believe has to be likely to cause it.
Certainly, Your Lordship.
Mr. Counsel, you have not mentioned the citations against the name of the cases. Without citation, how can we reach to that judgment?
Your Lordship, in the written memo submission that has been given, the citations have been.
Page 4, half of the citations are missing. See page 4 of your memorial. Starting from Arun Bhuyan versus State of Assam, Kedarnath, A.K. Gopalan, even there is no citation.
You
for
see,
it.
you should not work like this.
Page 4, have you seen?
If you do a thing, do it with perfection.
Your Lordship, the council would like to point out that in the footnoting in the.
Oh, that's fine,
in the
that issues. And I am looking at your list of abbreviations also. So here you have not taken TPC. TPC is missing. TPC is missing. TUAPA is also missing. Which are your major premises.
Your Lordship, the council has mentioned the provisions of CRPC and IPC
No,
and.
but you are not dealing with IPC.
Certainly,
You are
Your
dealing with TPC.
This is the forensic eye of a judge.
Certainly, Your Lordship.
And,
The council bows down to your
I am
wisdom, Your
sorry
Lordship.
that at serial number 2, Constitution spelling is wrong. Constitution of India. TUI.
Your Lordship, the council begs that it may be set aside as a typographical error, Your Lordship.
No, but.
No errors are exempted. Man.
Certainly, Your Lordship.
Anyway, proceed.
Go ahead. Now give us crisp. Don't here, there. Come straight away to your arguments.
Certainly, Your Lordship. Your Lordship, it is really contended that the essentials of defamation have been fulfilled in the present case. Your Lordship, referring to the Mr. Baskin ATI, which my most worthy opposing counsel said is not a part of the community. Your Lordship, the surname ATI itself makes Mr. Baskin ATI to be a part of the community ATI, Your Lordship. Your Lordship, further, ATI community is well identifiable and it is a well-defined class of persons against whom a defamatory statement can be made, Your Lordship.
They say, are you also this? It doesn't say you are also. See, there's a distinction between it.
Your Lordship, are you
You see,
also...
you say all Modis are chor. But here the question is not that. The statement is not that.
Your Lordship,
Statement is, there is a note of interrogation.
Your Lordship, the...
No, I am only... Job of a lawyer is very critical. You have to distinguish between the facts of one case from the other. And you must be ready to answer what can be the question from the other side.
Certainly, Your Lordship.
There was a lawyer, very busy lawyer. I don't know whether somebody has told you about it or not. There was a very busy lawyer, he did not have time to prepare a brief. So whenever he would get down at the airport, there would be a counsel waiting, briefing counsel waiting from the airport to the court. And therefore they would brief him. And once he entered in the court, he started arguing the matter and it appeared that he was arguing for the other side. Then his briefing lawyer said, sir, these are the arguments which favor opposite side. He said, is that? He said, these could be the possible arguments from the other side. Now I will demolish them. So you should be a lawyer of that standard.
Certainly.
First you prepare a brief against you. Then you prepare a brief how to demolish the other person's case and how you support your case. And in that process, don't ever take court for granted. Assist the court, and if a point is going against you, don't press for that point and take it in the end. First take up all strong points in favor of your client.
Certainly, Your
So
Lordship.
therefore we expect you to give all the best points first.
Certainly, Your Lordship. Your Lordship, in the same regard, it is crucial to note that the maximum punishment of an offence is not only the indicator of the seriousness of the offence, Your Lordship. In the present case, learned trial code, it imposed the imprisonment for maximum of 2 years, Your Lordship.
Where are the reasons given by the trial court why it has imposed maximum sentence in this case?
Your
Show
Lordship,
me, where is the reason given by the trial court why it is giving the maximum sentence in this case? Because when we talk about a judicial order, why do the judges get a lot of respect from the society? Because orders of judges, judicial orders are reasoned orders.
certainly, Your Lordship.
And they help in two ways. It helps the party to decide whether to go ahead or not to go ahead.
Certainly, Your Lordship.
See the merits of this case and demerits of this case. And it helps the appellate court while it is deciding the appeal against its order. So therefore, show me the reason why the CGM has awarded the maximum punishment.
Your Lordship, in the facts proposition, though it is silent, but Your Lordship, reference can be drawn as to the phrase
Why
that
should I draw a reference?
Your Lordship, to the phrase that graver the stature of the person, graver is the offence that has been committed by the person.
There are two aspects.
Certainly, Your Lordship.
When we decide on the question of the guilt, we go by the crime. When we go about the punishment, we go by the criminal. Then we go to the individualized treatment, punishment. Why maximum and why not minimum?
Yes, Your Lordship.
What is the reason in his case that they have given the maximum punishment?
Your Lordship, in the present case, the defamatory statement that was given by Mrs. Aku, Your Lordship, it was a statement, and Mrs. Aku is of a political stature, and she has the capability to influence the masses further as well, Your Lordship. Your Lordship, if the maximum imprisonment is not given by the learned trial court, Your Lordship, she also...
Have you read the order of the Supreme Court in Rahul Gandhi's case?
Yes, Your Lordship.
What does it say?
Your Lordship, it's regarding the stay of the...
Stay.
Certainly, Your Lordship.
Why have they stayed?
Your Lordship, the council is not aware as
You
to the
should
fact.
have read it because you should not come to the court without reading a judgment because this case is based upon that case only.
Your Lordship, it is still pending before the Honorable Supreme
No,
Court.
I am only saying on the stay.
Certainly, Your Lordship.
Rahul Gandhi
Your Lordship, since
not
the-
even in your list of cases.
You see,
Your Lordship,
these
it-
are things which you require to do.
Your Lordship,
When you know that this problem is 70%, 30% addition, 20% addition. The rest is just the same. And why should you not go through the judgment of the Gujarat High Court? Voluminous judgment. The Supreme Court says no reasons. CGM's order, voluminous order, but there are no reasons. That is why Supreme Court says no reasons by both. It warrants interference by the Supreme Court. So that's just a good lawyer will always read the last word. Yes.
Your Lordship, also in the matter that is still under the review and under decision of the Your Lordship, the council
This
did not.
depends upon your efforts, your hard work, and every person who is going to enter the final round. He has more responsibility
Certainly.
to be absolutely informed about the legal decisions,
Certainly, Your
which
Lordship.
of course is an interlocutory stage, but the question is, he got a stay. Many things happened. He became a member of the parliament. He would participate to represent his constituency.
Certainly, Your Lordship.
Can get back his Bangalore. Correct. Yes.
Your Lordship, the council would like to submit that since the opposing council has not at all proceeded with the
We have
request
proceeded
of,
with many things. You are to proceed now
Your
further.
Lordship, not with the request of staying the conviction that was done by
Anyway,
the
I'm only trying to say that
Sir.
you should do the readings properly.
Certainly, Your Lordship.
When you have a better case to argue, they have a difficult case to argue.
Certainly, Your Lordship.
Excuse me,
Your
sir,
Lordship.
sorry for interrupting. Is the environment okay? It's little hot and suffocating.
We're enjoying the environment very much.
One of the students actually fainted because of this. So just a humble request in
One
case
fan.
fan chalaane.
But ask those people who are going to be affected by it. I mean, you can put this fan also.
AC का temperature
For me,
high करके-
it's quite
Okay, sir.
comfortable, but my
I don't know about one of the students. She had some.
Yeah, I think breathing problem. Anyway, go ahead.
Sorry. Thank you.
Much obliged, Your Lordship. Your Lordship.
In nutshell, 1, 2, 3, 4. Give us 4 submissions.
Certainly, Your Lordship. Your Lordship, the first contention by the council would be that the class is an identifiable class and the statement is a defamatory statement, Your Lordship. The second contention given by the council would be, Your Lordship, that Mrs. Aku is that of she was the stature of a public representative, Your Lordship. Your Lordship, in the same matter, a passing of a comment in which she knew that, or she was likely to know that she was going to incite masses, or she was going to pass on a defamatory statement against an entire community, Your Lordship, she certainly would have the knowledge or the reason to believe that it would be a defamation against her, Your Lordship. Defamation for the masses, Your Lordship. Your Lordship, the council would move on to the next sub-issue, that is the section 151A of the TRP Act. Your Lordship, it is humbly submitted that it is not violative and it stands as a testament to the commitment of the legislature to uphold free and fair elections. Your Lordship, reference may be drawn to section 151A, the proviso of which states that the remainder of the term of member in relation to a vacancy when it is less than 1 year, then it cannot be conducted. However, Your Lordship, in the Moot proposition, paragraph number
Yes.
9, Your Lordship,
Yes.
pardon Your Lordship, paragraph number 8. Your Lordship, it states, Secretariat also using their powers under section 158(1)(a recommended by the 10th Election Commission. Your Lordship, the recommendation was by the Election Commission of India. Your Lordship, reference in the same regard may be drawn to the Nagaland Pradesh Congress Committee judgment. Your Lordship, referring to flag number 5 of the compendium submitted, page number 26 and 27.
26 and 27.
Flag 5 of the compendium of judgment submitted, Your Lordship.
Yes.
Your Lordship, it clearly states that there is no bar on the Election Commission.
Where are you reading?
Your Lordship, the highlighted part
How
of
can you highlight from the head note?
Your Lordship, it is on the next page as well.
Very, very bad. It is very bad. Head note is not a part of it.
Certainly, Your Lordship.
So therefore, where is the...
Your Lordship, the next page, the last paragraph.
Note is the mind of the editor,
Certainly, Your
not
Lordship.
the judge.
Your Lordship, council would like to draw
The
the
way
attention.
reading is para 7. Right?
Yes, Your
The
Lordship.
way reading of the above quoted section makes it clear that there is no bar on the election commission to fill up the casual vacancy even if remainder of the term of a member in relation to vacancy is less than 1 year. Proviso A to 1 is merely an exception to a statutory mandate that by election for filling of casual vacancy must be held within a period of 6 months from the date of appearance of the vacancy. The proviso does not say that by no means shall be held fill up the vacancy in the remainder of the term. Okay.
Much obliged, Your Lordship. Your Lordship, the council states that in the present matter, Your Lordship, an international delegation was bound to come to the state of Tem, referring to paragraph 9 of the facts. wherein it says that an international delegates visiting the big diplomatic conference was happening in the state of Tem. Your Lordship, at this point of time when an international conference was being held, leaving a constituency unattended, leaving it vacant, the vacancy of an MP seat, Your Lordship, it is not tantamount to state that it would leave a good impression of the state of Tem, Your Lordship. Your Lordship, therefore election...
What does the foreign delegation have to do with the vacancy, constituency remaining representative?
Your Lordship, not just the foreign delegates, but also the people of the constituency of the state of Gari were suffering at this behest, Your Lordship. Your Lordship, also referring to Section 151A, which has already been referred by the Nagaland Committee judgment, that Your Lordship, it needs to be that the by-election should be conducted as to not be against the fundamental rights of the people's right to choose their own representative.
Is there a fundamental right to choose their representative? Is right to election a fundamental right? Is right to representation?
It's a constitutional right.
Council, I have a question in Nagaland statement, you have read it. The portion which you cited and impressed upon, is it the ratio resident of the case?
As to knowledge of the council, certainly not.
But his petition was finally dismissed. No relief was given to the petition. Had it been ratio, then relief should have been given.
Your Lordship, it was held that the petitioner was that the filing of the by-election was ultra vires of the provision, Your Lordship. That's why the petition has been dismissed, upholding that by-elections can be conducted.
You see, I think
Within
what my lord is saying, and this is where I want to clarify something.
Sir.
The final outcome of a case has no bearing upon the ratio decision. The case may ultimately be dismissed, but the principle that emerges is the ratio of the case.
Certainly, Your Lordship.
So the ratio is that Election Commission has the discretion,
Yes,
and
Your Lordship, sir.
not holding the election when there is less than 1 year left is not mandatory, right?
Certainly, Your Lordship.
So, what is the difference between outcome
And the ratio.
and the ratio?
Certainly.
Please be very clear,
Certainly.
right?
Your Lordship, if the bench, the council would like to seek time extension for the issue 2.
Yes.
Certainly, Your Lordship. Your Lordship, the issue 2 is whether Mrs. Aku should be granted anticipatory bail with respect to FI number 54 and 19. Your Lordship, it is humbly contended that the learned trial court and sessions court were correct in rejecting the plea of anticipatory bail. Further, Your Lordship, reference as was drawn by the in respect to the facts of the case, that arrest has already been made, Your Lordship. Since this has been mentioned in the facts, Your Lordship, after the arrest, the anticipatory bail cannot be filed for. Even if for the sake of argument, Your Lordship, 438A, referring to the case of Ahmed Kuti Pothiel, Your Lordship, flag number 6, page 30, para 17 of the compendium of judgments. Your Lordship, it states that the Kerala High Court held that the bar on the grant of anticipatory bail contained in the provisions of UAPA is absolute. Your Lordship, herein Mrs. Aku is charged with section 13, 16, 17 and 18 of the Tempt Unlawful Activities Prevention Act and also declared a Schedule 4 offender under section 35 and 36. Hence, in no circumstances can she be provided an anticipatory.
The virus of schedule. She is challenging the virus of the schedule,
Certainly,
which
Your
gives power to government to include even an individual in the schedule as a terrorist.
Your Lordship, the council pleads that the
Presumption
challenges-
is it's a constitutionally valid provision unless the court strikes it down.
Certainly, Your Lordship. Your Lordship, my co-counsel will be dealing with the issue 4 as well. Your Lordship, it is most humbly submitted that Mrs. Aku, already sentenced for the maximum imprisonment, has been an offender and now has incited violence against the state, in which the reference referring to the video in question, Your Lordship. Your Lordship, in the present case, she has been termed as a repeat offender as well, Your Lordship, referring that earlier she has been convicted by the Learned Sessions Court and her arrest has not been made until 6 months of the conviction and the sentence order was passed, Your Lordship. The arrest has been made after the said video in question was circulated, Your Lordship. Your Lordship, this proves a repeat offence as well as a case of absconding by the accused, Your Lordship, as in Mrs. Aku did not submit to police custody even after being sentenced by the learned trial court, Your Lordship.
The conviction order was passed in his absence.
Certainly not, Your Lordship.
Then he should have been in custody before the court.
Your Lordship, the facts of the case are silent as to the matter. It just states that the judgment was passed and she was sentenced to.
Is it possible, according to CRPC, that a judgment of conviction can be passed even in the absence of accused? He is sitting in England and you are finding
Certainly
him
not.
here.
Certainly not. Your Lordship, as the arrest has been made later on, and till then Mrs. Aku was even allowed to circulate that video inciting the violence in masses, Your Lordship, it is presumed that Mrs. Aku did not submit to the police custody, Your Lordship. Your Lordship, further it is contended that, Your Lordship, custodian investigation is required in the present case as to the verification of facts if needed, as the charges levelled against Mrs. Aku are.
What is between judicial custody and police custody?
Your Lordship, judicial custody, as per the council's knowledge, is that when
As per the law,
Your Lordship, as per the council's knowledge as to the law, Your Lordship, judicial custody is when the Lordship, that the judge passes an order as to detaining a person, and police custody is when the person has been arrested by the police pertaining to an FIR in which
the person is arrested and within 24 hours has to be presented for the magistrate.
certainly, Your Lordship.
The magistrate has to decide on the basis of the request made to the magistrate by the prosecution to decide on the question whether the case calls for grant of judicial custody, police custody, or if the accused has made an application for bail or release of.
Certainly, Your Lordship.
So police custody has a definite time,
Certainly,
first 15 days,
certainly,
but judicial custody is unlimited,
certainly.
right?
Your Lordship, the council contends that the judgment was passed 6 months earlier.
Judicial
and-
custody is at the order of the magistrate remanding him to the judicial custody.
Your Lordship, after the conviction that was,
Right?
Your Lordship, after the conviction of the learned trial court, Mrs. Aku was not in custody. Your Lordship, further, it is stated that custodian investigation is required as to the verification of facts as the
What
charges
happened when
leveled.
she was convicted? Was she not present in the court? And if she was present in the court, did the court order that she should be taken in custody or she should be released on bail? The court has to decide either of
Your
them.
Lordship, no such order as to the bail of Mrs. Aku was passed by the honorable court.
Then she should have been sent to jail
She
immediately.
should have been sent to
Certainly, Your Lordship, that is the contention of the council.
That means your judicial magistrate either committed a mistake of law, you are representing state.
Certainly, Your Lordship. Your Lordship, the burden has been on Mrs. Aku as to Your Lordship surrendering after the conviction had been made. Your Lordship, the surrender to the police custody has not been made after the conviction.
Mr. Counsel, according to CRPC, judgment of acquittal can be pronounced in the absence of accused. But if it is a judgment of conviction, accused must be present in the courtroom.
Certainly, Your Lordship. if
And
the-
even in acquittal, 437A says he has to, take the bail.
Certainly.
Being on for 6
Bail on
months
for 6 months.
in case the state goes in the
If the
field.
state decides to go in the
Your Lordship, in the present case, it is clearly stated that Mrs. Aku was out even after her conviction. Your Lordship, it can be assumed or it cannot be consumed, but it is a fact that Mrs. Aku, on 11th August, another video of her surfaced, wherein she was not in jail, Your Lordship. She was a free person as to then, Your Lordship. She had not submitted to the custody, and assuming the facts of the case to the...
It is not the proper exercise of the power by the CJ. Because he had to decide when he convicted her. He has to decide whether to release her on bail or he has to put her behind the bar.
Your Lordship, if the decision was passed as to putting her behind the bar and she has still not surrendered, Your Lordship, that's why it is the contention that she is
Or was it
absconded.
that the judge said he waits till the time she gives a provision for appeal?
Yeah, see, section 389 is there in CRPC. The convicting magistrate has power to release her on bail till the time she files an appeal. That means the
Any of these things can
conviction order has to be suspended. Then your 8 clause 3 of Representation of People's Act also washes. Once the conviction order is stayed by the or suspended by
Suspension and stay are two different things.
Certainly, Your Lordship. Your Lordship, in the present case, the suspension has not been done.
Must have been done.
must have been done.
Your Lordship, the Moot proposition is silent as to the matter. Your Lordship, even for the sake of argument,
Anyway,
Your Lordship,
go ahead further.
Sir.
Finish your work.
certainly, Your Lordship. Your Lordship, a reference can be drawn to the judgment of the case of Sumita Pradeep versus Arun Kumar, referring to page number 46-47, flag number 8. Your Lordship, it states first and foremost thing the court hearing the anticipatory bail application.
You have not filed your case, this compilation of your cases?
Your Lordship, what we found was most of the cases that were relevant, we have told you orally, were either stated on the Moot memo itself, and for the irrelevant cases, we handled.
You must do it.
Sure, Your Lordship.
Should be part of your
Because
Yes, yes.
it leaves not very good impression,
Okay, Your Lordship.
right?
Yes, Your Lordship.
For learning, not for the purposes of any other
Yes,
thing.
Your Lordship.
Whenever you participate in a move, either participate or completely participate. Don't participate or completely participate.
Yes,
Completely participate means exactly the way what happens in it.
yes, Your Lordship.
That's why we call it a move.
Indeed, Your Lordship.
We're preparing you for something which you will do tomorrow.
Definitely.
So that you don't commit these mistakes.
Yes, Your Lordship.
Therefore, this is learning.
Yes.
This is learning how to go about it. Compilation of judgments, properly edited submissions, and citations in alphabetical order with the page number where you are referring to, so that it is easy for us.
You have not mentioned page number.
Page
See, these
number.
are things which you should learn.
Yes, Your Lordship.
You see, we always commit mistakes, but then mistakes must not be for repeating mistakes. Mistakes must be for doing things better.
Your Lordship, the Council most humbly submits that anticipatory bail in the present matter is not maintainable, as has already been argued by the Council. Your Lordship, also enough grounds have been given to reject the bail in view of the public security as well, Your Lordship, since a video of the same stature can again incite the masses, and Your Lordship, Mrs. Aku being a political figure of political stature, Your Lordship, he has the power to incite the masses again. And Your Lordship, even if the bail application, a normal bail application is passed.
Is there a difference between public order and law and order? An act of an accused can create a law and order problem. But if it creates a public order problem, that becomes a serious. Would you put it as a law and order issue or is it a public order?
Your Lordship, the Council believes that it is a public order issue, Your Lordship, since referring to the 9th point of the facts, Your Lordship, it states that there was destruction of life and property on the basis of the video, Your Lordship. Paragraph number 9 of the facts, Your Lordship, 5th line, 6th line, Your Lordship.
Yes.
Lordship, state police as well as central police were deployed since there was destruction of life and property on the basis of the video, Your Lordship. Your Lordship, the Council, if the Honourable Bench is satisfied with the first two issues, the Council seeks permission for co-counsel.
Sit down. Okay.
Mr. Counsel, you have referred to the case of Shreya Singhal versus Union of India. What was held in this case?
Your Lordship, the co-counsel will be dealing with the issue number 4 in which the
Can you
judgment
answer
has
right
been
now?
cited.
Can you answer?
Much obliged.
Shreya Singhal's case.
Much obliged, Your Lordship. Your Lordship, in addressing the Shreya Singhal judgment pertaining to the importance
Who
of
wrote the
interpretation.
judgment in that case?
Sorry,
Who wrote the judgment in that case?
Your Lordship, the Council is not really aware of the fact.
Why?
Your Lordship, the Council knows the ratio.
Justice Nariman.
Right, Your Lordship.
Yes. Oh. Okay. When your turn comes, then you can speak.
Right, Your Lordship.
But Mr. Counsel, in the top of your memorial, the spelling of Supreme Court is wrong. I am sorry to say. You have written the P is missing. Supreme Court of
Supreme Court.
Supreme Court. Spelling is mistake. see.
ये रहना नहीं चाहिए. These things should not be. These are the teachers in charge of the Moot society.
Supreme Court, spelling is
Certainly, Your Lordship.
Constitution, spelling was wrong.
Your Lordship, it may be brushed aside like typographical error, Your Lordship. Much obliged, Lordship. It was
Last
an honor.
question, you have both section 25 and 27 of Arms Act also in FIR number 19. What is this section 25 and 27? Arms Act.
Your Lordship, the FIR that was filed was in relation to the public riots and the destruction of life and property that was on the basis of that video, Your Lordship. In that reference, section 25 and
25 27 requires recovery of unlicensed revolver or gun or ammunition.
Certainly.
Was something recovered?
Your Lordship, as the FIR was allowed by the learned trial court and high court, it can.
There is no allowed disallow.
Certainly, Your Lordship, as it was, Your Lordship, it is given
Charges
that
were framed.
the charges were framed and they were accepted by the learned.
Provisions were not.
Certainly, Your Lordship. The council at this moment doesn't have the evidence as to the same, but presuming that the learned.
It must have been dropped.
Certainly, Your Lordship.
Was it dropped or the charges are continuing? 25 27.
Your Lordship, as per the council, it was not dropped, Your Lordship.
Not dropped.
Okay. It was an honor arguing before the honorable bench.
The council seeks permission to approach the trial.
Yes. See, brevity is something which is very, very important for the lawyer. So we expect you to be brief,
Right.
to the point, and of course the best.
Right. Your Lordship, if it may please the court, the council seeks permission to approach the bench collectively as your Lordship for the sake of convenience.
We can usually collectively rest on the things we can say.
Your Lordship. Your Lordship, the council is here in the present case of Mrs. Apu versus State of Gari, wherein the council, with the due permission of the bench, the council would like to begin with the arguments pertaining to the third and the fourth issue at hand. Your Lordship, the council will be starting with the third issue, wherein
The first issue is what my lordship, please tell us what was Shia Singh.
Right, Your Lordship. Your Lordship, bringing your attention to Shreya Singhal versus Union of India, which is given on flag number 17 of the compendium submitted on behalf of the respondent. Your Lordship, an argument by the respondent in this matter is that the said video, wherein the petitioner asked for the removal of the said video, it was actually the duty of the intermediaries in this matter to remove the said video, and the press investigation bureau did not have the jurisdiction to actually go and remove the said video, which was clearly stated in the said case. If your Lordship would permit me to read the same.
Yes.
The Shreya Singhal versus Union of India
What
upheld.
is Shia Singh decide?
Your Lordship, the council is aware of the ratio decidenda of this case, wherein the Kerala Police Act, which was in question in this.
There is a provision of the IT Act.
Yes, Your Lordship. However, it was actually held that the Kerala Police Act was struck down being violative of Article number 19, subclause 1A, and it was not saved by Article 19.
What about section 66A?
Yes, Your Lordship, it was also struck down in this
Why?
section. Your Lordship, it was found to be against the fundamental rights and against the basic.
Why?
Your Lordship, the council pleads ignorance in this matter as he is not well versed.
Because they say it is very vague. The criminal provision has to be definite. You cannot do vague definition of an offence and leave scope for arbitrary exercise of the powers.
Right.
Because it was not specific, it was not referring to what actually legislative intent in clear terms was. So therefore, being vague, ambiguous.
Right, Your Lordship.
You should never plead ignorance. You know,
Right.
you are the more learned part of the society.
You are the most unlearned, they don't know,
Yeah.
they don't need law, they don't be taught law.
Right. The council bows down to the wisdom of this honorable bench. Your Lordship, the council in this present issue number 3, will be dealing with threefold arguments, wherein the first one being that the said video incited public violence and there was a threat to the national security in question. The second one herein being that alternative legal remedy was available. to Mrs. Aku which she did not exploit, and the third one being that the argument pertaining to the non-involvement of the press bureau, which is a supplement to the second sub-argument. With the permission of this honourable bench, the council would like to elaborate upon the arguments of the said issue. Much obliged, Your Lordship. Lordship, Mrs. Aku's participation in a video that directly incited violence and during an international diplomatic conference which should be taken into consideration, it actually constitutes a grave offence against the public order and the safety. Your Lordship, her actions violate the principles of public order and safety as they have the potential to result in violence, damage of property and... Right. Your Lordship.
You won't hear your notes.
Much obliged, Your Lordship. Your Lordship, her actions basically are said to be against the violate the principle of public order in this matter. Your Lordship, if I bring your attention.
What is public order? How is it different from law and order?
Your Lordship, public order can be stated to be when the public is out of control and the public, as in the said matter, as seen on paragraph number 9 of the Moot proposition.
Any provision in Constitution of India where public order word is used? There are two articles. When we read with the freedom of religion, it starts with subject to morality, public order and what does it say really for us? What is it? Read.
Your Lordship, Article number 26, wherein the freedom to manage religious affairs.
25, 26, 25 and 25.
Right. Article number 25, the freedom of conscience and free profession, practice and propagation of religion.
Yes.
Subject to public order, morality and health, and to the other provisions of this part, all persons are equally
Public
entitled.
order, it's not law and order.
Right.
You have to be very clear on public order.
Right. Council power. Your Lordship, in this said matter,
You have a freedom of religion, conscience. And these are the only two fundamental rights which are subjected to. Public order is paramount.
Right.
Morality is paramount. Health of the people is paramount. And other provisions of the Constitution are paramount. Then comes your freedom of religion, conscience.
Right, Lordship. Lordship, supporting this argument, the Council would like to bring your attention to paragraph number 9 of the Moot proposition. Wherein, Your Lordship, Mrs. Aku, wherein she was found to be stating and inciting violence with respect to international delegates. And coming to the next line, the state police as well as the central police were deployed since there was a destruction of life and property. Your Lordship, paragraph number 9 of the Moot proposition.
Yes.
Your
The
Lordship,
state police as well as the central police were deployed since there was destruction of life, property
on the basis of this video, Your Lordship. So, Your Lordship, as my co-counsel was questioned in this matter regarding the certain sections which were put in this FIR, Your Lordship, there was a certain destruction of life and property as the Moot proposition clearly states. So that is why the state had to have some additional section in this matter.
Your Lordship's question was regarding Arms Act.
Arms Act, Your Lordship.
How it will
Your Lordship, the Moot proposition is silent on the fact of Arms Act, whether there were actually any recovery of any arms. However, the council here pleads that if there were charges framed in this matter, there needs to be an assumption that there was actually a recovery of arms in this matter.
No, there can't be anything in criminal law or basis by the evidence.
Right, Your Lordship. Your Lordship. Right, Your Lordship.
Now, how do you deal with her argument when she says that the video was a fake video?
Right, Your Lordship. Your Lordship, being a prima
And
facie.
she says she made a request that it should be removed from the site.
Your Lordship, the line
They
is
say that Abu made a press release
right, Your Lordship.
before her arrest,
Right, Your Lordship.
wherein she stated she had never said these words and is an AI created deep fake video
Your Lordship.
and applied before the press bureau for declaring it to be fake news under the 10th Information Technology Act.
Yes, Your Lordship.
Press bureau declined to intervene
Your Lordship,
because press bureau seems to be the arm of the state.
yes, Your Lordship. The council would be stating here that the press information bureau in this matter is a government agency and it is only responsible for disseminating the official information, and it should actually refrain from interfering in the enforcement of criminal laws in this matter.
There are fake videos.
Your Lordship,
When
in this,
you want to implicate a person in the fake, as an accused in serious offences, and she requests that it be removed and it be investigated before she is arrested. Is she not within her right to say so?
Your Lordship, the Council takes the reference or the backing of section number 79 of the IT Act. The Council would read it out for the sake of readings. Of section 79 of the IT Act, Your Lordship, it is on, the Council admits that it is on,
Why do you say?
Your Lordship, I am referring you to the paragraph in the memorial submitted on behalf of the respondent.
Okay.
Your Lordship, paragraph number 53. Yes, Your Lordship. Paragraph number 53, page number 24.
Page number 24.
Paragraph number 53, Your Lordship.
Alternate legal remedy available.
Yes, Your Lordship.
What is the alternate legal remedy?
Your Lordship, the Council takes the reference or the backing of section number 79 in this matter. Section 79 of the IT Act provides a mechanism for intermediaries to remove or disable access to content upon receiving a formal complaint or notice. Your Lordship, instead of pursuing this legal avenue, Mrs. Aku opted for a press conference to declare it to be a fake news. Your Lordship, the Council would like to bring your attention to two main important areas of this specific section, wherein it was the duty for the intermediaries to remove the said news. Mrs. Aku going overboard those intermediaries to the Public Investigation Bureau in this matter would not amount to a proper procedure of law being followed, and the second one being that upon receiving a formal complaint in this matter, Lordship, just a press release which was made after arrest does not amount to a proper notice or a proper formal complaint in this matter, Your Lordship. This is the contention of the Council in this matter.
Yes.
Now, how would the result of the case will be affected by this paragraph number 53?
Your Lordship, as the Council is also representing the Press Information Bureau in this matter.
State also. State also.
Yes, Your Lordship. Your Lordship, the Council contends that the Press Investigation Bureau did not have the jurisdiction to actually remove the news.
That's fine, but how this argument is going to affect the result of the petition?
Your Lordship, a proper procedure needs to be followed is what the Council is contending, and as stated in issue number 3 of the...
You mean to say petition should be dismissed?
Yes, Your Lordship.
This you have not written in your prayer clause. See page number 34.
Yes, Your Lordship. Your
You
Lordship.
have never mentioned, nowhere mentioned that petition of the petitioner is liable to be dismissed.
Your Lordship, in the interest of justice, the Council would like you to ignore the said argument because the Council made a typographical error.
State, you can be removed from your position by the state. If you are not arguing for state, you are arguing for
Yes,
petitioners
sir.
probably.
I hope that's not the case, Your Lordship. However,
Do you have prayed? Please
yes,
see.
Your Lordship, and the Council understood the mistake.
Last page prayer, please see.
Yes, Your Lordship.
Have you ever prayed that petition should be dismissed?
Your Lordship, the Council understood the mistake in this matter and has already handwritten the same so as to not forget it in the
You
matter.
see, you are a respondent.
Yes, sir.
You can't make prayers to the...
Right,
You can
right,
only ask for the dismissal of the petition.
right,
You can't say do this, no. Then you have to file another petition.
right, Your Lordship. It's a learning
You are
curve
not
for
the
the Council.
petitioner. You are not the petitioner. This is very serious.
Right, Your Lordship.
Prayer 2 is saying something.
Prayer to is...
You will have to sit down with them.
No, that is right. But then on the question of criminality or depositions against the person
Right, Your Lordship. Apologies for the same, Your
or
Lordship.
enforcement of the rights under 32.
Your Lordship, the
You
Council.
have written also very good in prayer clause. Pass any
Any
other
order.
order
In the interest of justice.
In the interest of justice, equity and good conscience. Is the Supreme Court court of equity?
Your Lordship, no, it is not, and it is again. The Council would like to state that the Council has learned from the mistake and has actually.
No, are we court of equity or are we court of law?
Your Lordship, the court of law.
Or mixture of two?
No, the court
But
of
then
law.
just look at Article 142.
Yes.
Complete justice between the parties.
Court can pass any order in the interest of justice. Read it so that your other friends can also get benefited.
142, please read it.
And very important, 141 says law declared by the Supreme Court shall be binding on all courts.
Right.
142 says Supreme Court can pass any order. What I can say, just read it.
Enforcement of decrees and orders of Supreme Court and orders of discovery, etc. The Supreme Court, in the exercise of its jurisdiction, may pass such decree to make such order as is necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India in such matter as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made in such matter as the President may by order prescribe. The second
That is, 141 is sterilizes. 142 is not binding because it can't be binding precedent because it is with respect to that case before the court.
right. A learning curve for the council.
No, whether lower courts are bound by the judgment of the Supreme Court declared and passed under Article 142.
No, your lordship, it is under 141 wherein law
No, I am
declared.
asking 142.
No, your lordship.
It doesn't have any res to decidendi for future.
Your lordship, it does, but only binding on all the
It will
courts.
only with respect to facts and practice.
Right.
Peculiar facts.
Right.
Like irrevocable breakdown of marriage is not a ground for divorce. The Supreme Court can dissolve a marriage where it feels it's irretrievable breakdown. And it has done in many cases. Right?
Right. Your lordship, the council would like to, if your lordship is actually satisfied with the argument pertaining to the third issue, the council would like to proceed to the fourth issue.
Yes.
Much of that, your lordship. Your lordship, due to the scarcity of time, the council would like to briefly summarize the arguments in the present issue. Much of that, your lordship. Your lordship, the council here states that there is a provision for reasonable restriction under Article 19. So,
All
your
of us
lordship,
know it. All of us know it.
yes, yes, your lordship. Your lordship, the fourth issue herein talks
Only
about.
question is how reasonable is the reasonable restriction?
Your lordship, the council would like to bring your attention to the case of A.K. Gopalan versus State of Madras.
That has been overruled by Maneka Gandhi and Minerva Mills.
Yes, your lordship, for which the council has another.
Minerva Mills was 9 judges, Maneka Gandhi was 7 judges.
Your lordship, the council has
And
another.
A.K. Gopal was only 5 judges.
Right, your lordship. Your lordship, in the case of Arup Bhuyan versus State of Assam, the Supreme Court held, which is lordship, which can be found on the plan number 9 on the compendium submitted on behalf of the respondent, wherein the Supreme Court held that the speech and expression that incites violence or disrupts public order can be curtailed in the interest of public safety.
Okay.
Your lordship, the court emphasized that maintaining law and order is essential to a democratic society, and the state has the authority to take.
What did it say? What did the court say?
Your lordship, the court emphasized that maintaining law and order is essential to a democratic society, and the state has the authority to take measures to prevent violence and ensure public safety. In this matter, your lordship, as we bring your attention to paragraph number 9 of the Moot proposition again, there was a destruction of life and property on the basis of the said video, your lordship. Your lordship, it actually, your lordship, Mrs. Aku in this present matter cannot hide behind the curtain of reasonable.
This is fake.
Your lordship, being a prima facie evidence,
Please remove it from the.
it brings the burden of proof to Mrs. Aku in order to prove the same, your lordship.
Alright.
Right, your lordship.
Is it burden of proof or onus of proof?
Your lordship, the onus of proof in this matter, because this is the first, because if she would have actually given proof regarding the same, the burden of proof is.
You are not the court. Why should she give proof?
Your lordship, to this honorable court itself, not to us. Your lordship.
What is the distinction between burden of proof and onus of proof?
Your lordship, the burden of proof in this matter, the onus of proof is that if there is a certain contention, the proof needs to be directly given, and the burden of proof in this matter is to repudiate the proof or something like that, with the limited knowledge of the counsel.
Never say limited knowledge.
Right.
The knowledge is vast.
Right. Right.
Anyway.
Your lordship, the council would like to bring this Honorable Bench's attention to the TUAPA Act, which is in question, the 10th Unlawful Activities Act. Council would like to give the bench a copy for the same. Lordship, the council would like to bring your attention to section 35, subsection 3C of the said act.
Yes.
The Lordship, which talks about the central government may by notification in official gazettes, subsection 3 of the said act. For the purposes of subsection 2, an organization or an individual shall be deemed to be involved in terrorism if such organization or individual, bringing your attention to subsection 3 in this matter, promotes or encourages terrorism. Your Lordship, Mrs. Aku in this present matter can be found to be stating and inciting violence through that prima facie video in this matter, Your Lordship.
You are referring to which part? 35?
Your Lordship, section number 35, chapter 6.
35, which
Your Lordship, subsection 3C.
3C promotes encourages terrorism for the purpose of organization or an individual shall be deemed to be involved in terrorism if such organization is individually commits, participates in the terrorism, prepares for terrorism, or promotes or encourages terrorism, or is otherwise involved in terrorism. What is the definition of terrorism?
Your Lordship, section 15 of the 10th Unlawful Activities Act gives a definition of terrorism.
I'm looking at it.
Yes, Your Lordship. Section 15.
Yes.
Your Lordship, whoever does any act with the intent to threaten or likely to threaten the unity, integrity, security, economic security or sovereignty of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people of India or any foreign country. Your
What is
Lordship,
terror?
sorry,
What is the definition of terror?
apologies, Your Lordship.
Definition of terror.
Right, Your Lordship, terror.
Which provision?
Right, Your Lordship. Your Lordship, the council would like an extension of time just to conclude.
Yes,
Right.
yes.
Lordship, a terrorist
2A.
act, Your Lordship.
What is terrorism?
Have the meaning assigned to it in section 15, and the expression terrorism and terrorist shall be construed accordingly.
Further,
Your Lordship, a terrorist gang is given on L. Terrorist gang means any association other than terrorist organization which is systematic or otherwise which is concerned with or involved in terrorist act. Your Lordship,
anyway.
Your Lordship,
Please conclude.
yes, Your Lordship. Your Lordship, the council would like to bring your attention to another section of this act, which is section number 36, which are section number 36 and 37 of the said act, Your Lordship.
Yes.
Your Lordship, section number 36 gives talks about the provision of denotification of a terrorist organization or individual, and clearly states that a proper procedure for the denotification in this matter of the name of the organization or the individual in question. Your Lordship, a terrorist once brought upon Schedule 4 can also... Yes, Your Lordship, the council here states that Mrs. Aku does fall under this said section.
You say it can be only when it is denotified that she can be out of it, but as long as she is notified, she is in it.
Your Lordship, the council here contends that the arrest of Mrs. Aku is actually a preventive measure in order to ensure that the terrorism activities are under control, and which can also be denotified in the said matter from section number 36 and 37. Your Lordship, the council here contends that once a terrorist, once a person is under...
Once a terrorist, always...
No, Your Lordship, once a name is under Schedule 4 of the... No, Your Lordship, once a name is under Schedule 4 of the said act, it doesn't mean that the person is a terrorist for life. There's a procedure for denotification, and the council would also like to point out to section
There is a
number...
scope for reformation.
Your Lordship,
Therefore, denotification.
Your Lordship, the council here contends that it is actually a preventive measure. And section number 37 of the act clearly states that there should be a committee which should review this, and it should consist of a chairperson who shall be a judge of the High Court.
You were saying that. You know that.
Your Lordship, the council is just contending here that
You are saying that
there is a
once
balance
she has
of...
been included, she by her good behavior can always be
Your
notified
Lordship,
once the committee reports so.
Your Lordship, good behavior is not in question in the said act. The said act clearly talks about denotification, because after a review committee finds...
Thank you.
I request both the teams to come in front.
Your Lordship, the council would like to proceed with the prayer.
So, you got your, please come, please come.
The council
Both the
seeks
teams, please.
rebuttals.
No rebuttal is required. Yeah, I'm asking you a question.
You see, judges
Both
are
the
in
teams,
careless.
both the teams and the audience also. If anybody from audience can answer, it shall be appreciated. I'm asking you what is the distinction between a writ and writ petition. First of all, teams will answer, otherwise audience can answer. Distinction between writ and writ petition. Yes, students of Maharaja sitting here, please come on.
Yes, yes.
Yeah.
Writs are the files that are mentioned in the that mandamus, habeas corpus and all these. And writ petition is the petition that is being filed for the enforcement of that writ. Correct me if you are
Yes,
very
wrong.
good.
That is the correct thing. Court can issue a writ, but upon what?
Writ petition. The writ
Once the
petition.
petition is presented to the court under Article 226 or Article 30.
So that girl your name?
Vani.
Shivani and
Vani. V-A-N. Vani.
Vani, very good. Okay, next question to you is, how do you find out the ratio decidendi of a case? What is the method? How do you find out?
Upon which something is held in the said matter.
No, it was held in this case, it was held in this case is the wrong
Your
notion
Lordship,
of ratio.
that is the rationale on which the judgment has been held. Ratio
Rational on the basis of the judgment has been
In
held.
what context?
in what
Context.
context?
See, once a question is before the court is expected to answer only that question. It can make 101 observations here and there. That is why we make a distinction between ratio decidendi and obiter. But obiter offers a text code. And sometimes also is a matter which cannot be resolved. But ratio 141. Law declared on the issue before the court. Legislature makes a law which is of general application. Courts are seized of the issues and they decide the issues. The principle that is laid down by the court is in the context of the issues that have arisen for its determination. Therefore, I think
Yeah.
my Lord will be able to further clarify.
No, I think my word is correct. The reason behind the decision with reference to particular issues. That's why I was saying whether the petition was ultimately dismissed, how it can be the ratio. Some judgments may not have any ratio. Sometimes Supreme Court is writing heard, dismissed. What is the ratio? Okay. Next question to you, State Council, is which mode of citation you have adopted in preparation of your memorial? Which mode of citation you have adopted? Blue book. Have you ever seen blue book? Library में देखा है? Is it available in your library? Your library contains blue book. Any other student can answer? Which mode of citation is prevalent in our country? Blue book.
Indian Law Institute.
Blue book and ILI. Adopted by ILI. Indian Law Institute. And the last question for you is, what is an exhibit mark? FIR is marked as exhibit A1. What does it mean? State Council will answer first.
You are the prosecutors.
Yeah.
Your Lordship, as per the knowledge of the council, it is the exhibit that is the evidentiary value that is supplemented.
Value is to be assessed by the judge.
The evidence that is
What is
submitted.
the meaning? एक छोटा FIR में box बनाया जाएगा, उसमें लिखा जाएगा exhibit A1 signed by the presiding officer. But does that mean, marking of exhibit on a document?
So, Lordship, it is the certification as to the maintainability of the FIR, as to that the FIR has been, the charges that have been levelled, they have been confirmed and they have been.
Would you like to explain what is the meaning of marking of exhibit on a document?
Lordship, whenever a written submissions are given, along with it the FIR is attached in exhibit, in which the exhibit is attached.
Any student of Maharaja Hussain would like to throw light on marking of exhibit? What does it mean? See, when a document is duly proved before the court. I was a lawyer of FIR. I proved it before the court that this contains my signature. My name is Dr. Naresh Kumar Bahel. It contains my signature. I identify my signature and I had lodged this FIR. Exhibit
These are the contents what are involved.
When you are proving the contents of the document under your own signature, then exhibit is marked. Evidentiary value is something different.
That
It
is what
assessed
is
later on.
sir. There may be FIR, ultimately the credibility of the person who files the FIR may be shaken. And what is the evidentiary value of FIR? In your view? बड़ा करो यार 145, 157 of the CRS.
When FIR is contradicted by the statements of the witnesses, contradictions are there. According to 145, the value goes down. If the contents of the FIR are supported by the witnesses in the witness box, they are corroborating the contents of FIR, its value is increased.
Because FIR is never on court. So it can't be evidence as a substantive.
So, very good exercise
Very
by
nice.
all of you.
Good.
Before we close, again to both the teams, last question, and I'll not ask you more questions, the last. Can you distinguish between constitution and constitutionalism?
If a person answers this question, we decide to get tied.
Yeah, this is a
Tiebreaker.
for both the teams.
Anything that follows the spirit of constitution can be considered to be constitutionalism, and constitution is a bare text of formed by the framers of the constitution.
If we were to make a Venn diagram, constitutionalism would be a bigger circle than constitution. Constitution is something which is written in the book, which is amended by the parliament, and which gives the country its basic law of the land. But constitutionalism, in my understanding, is the spirit on which
This she said the same thing. She said operationalization of the constitution and its ethos.
Any student would like to add the distinction? Yeah, please.
So constitution means the rules and regulations of the country, and constitutionalism means the limitations of the country, like a limitation of the rulers or the government in a country.
Constitutionalism you are asking.
Your
Your name?
Himanshu.
We appreciate your effort, at least you stood up to answer the question. Very good.
Good governance of a nation where judiciary, executive and legislature act in accordance with the spirit of the scheme of the constitution. It is operationalization of the constitution in consonance with the rules of the game.
There are, thank you everyone. Yes sir, please.
There are two kind of writs in the constitution. One under Article 32 and another under 226. What is the difference between these two? And the second leg of the question is that which is the having the vast?
The question is this: whether the Supreme Court has more powers or the High Court has more powers while exercising their jurisdiction.
In
or whose jurisdiction is wider?
The High Court's jurisdiction is
Why?
because along with other fundamental rights, the High Court can also practice under 226 legal rights can also be the violation of legal rights can also be.
Would you like to contradict that?
Your Lordship, the council would contend here that under 226, a person's rights in his personal capacity would also be taken up in
Why not under the 32?
Your Lordship, the Supreme Court does not take personal.
My liberty, habeas corpus.
Certainly, Your Lordship.
My right of violation of Article 2021, speedy trial,
Your
fair
Lordship, that
trial,
is the basic structure.
legal representation.
That is the basic structure, Your Lordship. However,
Your Worship, also in the present case, the writ was not maintainable, and Your Worship
Why?
stated that.
They say that.
Your Worship, because it is not just a question of
You know
fundamental.
Ambedkar said about 32?
It is the heart of the Constitution.
Heart and soul of the Constitution.
Certainly, Your Worship. Your Lordship, but in the present case, the
And you know
application for
what it said about 32? Further? Access to justice for the common man from in the top court right to the Supreme Court. Enforces fundamental rights.
certainly.
Thank you, dear students. Please sit down.
Thank you.
Thank you, Your Lordship. It was pleasant time.
Please sit down.
You want to rebut the arguments? You know what to rebut.
Thank you, Your Worship.
Please sit down.
thank you, Your Lordship.
All of us.
I request the escorting team to kindly take the participants to 9472.
Yours?
Excuse me?